back on the record. Mr. Nichols, have you had an opportunity to review your file?
I have, Your Honor. It appears that there was a bond hearing May 5th, 2026. And I think the court heard evidence at that point concerning this offense and another offense.
I did. I mean, there was a previous one. I don't know the exact date, but it was sometime. It was just like, let's see. So is there any change that you see, Mr. Nichols?
No, Your Honor, I don't.
Any reason would you, any agreement or reason that I would reduce the bond?
No, Your Honor. I would just re-urge everything that you've been over before. Ask you to keep it how it is.
Give me just a second to go back and look at the PC to remind myself what the allegations was.
The allegations concern him having a fight with a female in the vehicle, stabbing her with a pocket knife while she was driving and then causing the vehicle to crash.
We naturally kind of disagree with her version of the facts.
Can hear you, Mr. Mackey.
Speak up, please.
We naturally disagree with her version of the facts. Mr. Mullins and Mr. McWade were in a relationship, and this was a fight that escalated. Change since the last time is that he now has definite employment waiting for him at Neutron Electric. What is their name? Neutron Electrical. He's a electrician and would go there and work and live at home with his parents. And have nothing to do with Miss Mullins.
Give me a second. I'm just looking at a couple of things. All right, I'm not inclined at this time to modify that prior ruling. I will look back and have the court reporter pull up to make sure that we didn't discuss anything about the job, but at this point, we just need to get the case set for whatever it's gonna get set for.
I believe there's been a rejection, Your Honor.
Yeah, it's set for trial.
Oh, it's already on the trial docket.
It's set for September 14th.
Okay, all right, then, well, I'll do my best to see if it can be at the top of the list on that day. If for some reason it's not reached on that week, then at that time I would consider an additional motion.
Okay,
Because
thank
I
you.
would consider that new, obviously, if he has to sit and wait for another trial docket. Okay,
Thank you.
all right, thank you. All right, you're Giovanni Coleman.
Yes, sir.
This is cause number 25 DCCR 0479. Mr. Coleman is charged with the first-degree felony offense of murder. And what is the the announcement?
Judge, we are very, very close to an agreement that will resolve this case without a trial. There are some technicalities that need to be worked out and need to be approved by various people. I think Ms. Malfino will agree with that assessment. But we believe this is going to get resolved. Mr. Coleman agrees in principle with the deal that we have worked out. So
Speak up.
I'm sorry. Mr. Coleman agrees in principle with the deal that we have. So we're asking for.
And Judge, if I may, I just put my spin on that.
Please.
I would-
Because, and here's
I
my
would not so
concern.
strongly say that we have an agreement in place. It's not like we're waiting for the ink to dry. I think what we're saying without saying it so much is that we have had a very productive conversation, which a lot of times in these elevated first degree cases, we're not even able to get to that point. I am not in a position to make the offer that we have discussed. And if that requires me placing it on the trial docket, knowing that I need to come to the court in advance, if that offer does make itself
Here's what we're gonna do.
doable.
You've been on since last May, so we're 14 months into your representation. I'm last reset, figure out what you need to figure out to whatever the offer is, it is. I want a final offer, yes or no to take it or not, and then if it goes on the trial docket, all of that needs to take place between now and that next announcement.
Okay, we're ready.
This
for
will
that.
be the last one.
Okay.
Okay, all right, you go back with the bailiff. Good morning. Are you Jadarius Simmons? And this is 26 DCCR 0661. Mr. Simmons is charged with unlawful possession of a firearm by felon. And what is the announcement?
We're asking for a 30-day reset. We're at the end of the road.
You're what? I'm sorry.
We're at the end of the road here. We're on the same page. I think we just need to flesh out a few things.
I inherited this case from Mr. Coleman. I have tendered an alternative offer based on my read of it. I'd like maybe later DAs to look at that and see if they agree, just because of the variance between it. I don't know that he's been in custody that long. It would be a jail time offer, and so I don't know that that's an issue, but we could probably have it resolved by.
Yeah, it's fairly new case and you were just,
Yes.
filed your representation
Yes.
just a few weeks ago. So yeah, we'll just do a normal reset, about 30 days or so. That'll give you some time to get with Ms. Malfino to talk with whoever she needs to. I'm sure Mr. Cole will be out there to visit with you about what your options are before that next court
And
date.
just so his client knows, if I may, Judge, Mr. Cole has reached out to me multiple times. We've had numerous conversations already.
Good. Okay, perfect. Thank you.
Thank
Thank you, Mr. Cole. You can go back with the bailiff. Good morning. Would you please raise your right hand? Do you swear or affirm you'll truthfully and accurately translate from English to Spanish and Spanish to English?
Yes, Judge.
Thank you. And Mr. Kimler, will your client waive the formal reading of the indictment?
Sure.
Sir, are you Jose Torres Lopez?
Eres Jose Torres Lopez?
Yeah.
Yes, Judge.
Mr. Torres Lopez, you're charged in cause number 25 DCCR 0211 with the state jail felony offense of solicitation of prostitution. And that's from December 19th of 2024. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily?
Estás suplicando culpable libre y voluntario. Y tienes que decir sí o no.
Free, nobody's making him plead
Que
guilty.
nadie está diciendo que tienes que decir culpable, ¿verdad?
Answer out loud for her, please.
Yes, Judge.
Are you pleading guilty because you actually did what they charged you with?
Y estás diciendo culpable porque existe lo que le está diciendo que existe. Que sí existe el cargo.
Sí, culpa.
Yes.
I have here on the tablet some documents that have your signature on them
Tiene unos documentos a mi tablet que tiene su firma,
that the state's marks as exhibit number 1.
que están en
Before you signed these, did you go over them with Mr. Kimler and the translator?
Antes de firmar esos documentos, sí te explico todo en español y su abogado también. Yes, Judge.
Do you fully understand those documents?
Y usted entiende todo que firmas. Yes, Judge.
Do you understand if I follow the agreement that you made with the district attorney, that you'll be waiving any right to appeal?
Y usted entiende que si ella va con lo que firmaste que estás dejándote derecho para apelar el caso. Yes, Judge.
It looks like the agreement that you've reached is for a 3-year deferred probation with a $300 fine.
Y lo que firmaste 3 años de probation y con una multa de $300. Yes, Judge.
Do you also understand, if you're not a US citizen, that a plea of guilty or no contest
Si usted no eres ciudadano, una de culpable,
may result in your deportation,
se pueden deportarte,
exclusion from admission to the country,
salir del mundo,
or denial of admission or denial of naturalization under federal law?
que no se puede, que si entiendes eso. Yes, Judge.
State tenders number 1,
No objection.
it's admitted. Is there any evidence that Mr. Torres Lopez is not competent?
None that I've observed, Your Honor.
Ms. French, what's the state's position with regard to waiving pre-sentence reports?
State will waive, Your Honor.
Right, state's one's admitted then. Mr. Torres Lopez, I'm going to find that you entered your plea of guilty freely and voluntarily.
Siendo que usted entró su pecado libre y voluntario.
Find that you're mentally competent and you understand the nature and the consequences of your plea.
Que usted entiende lo que está pasando en el momento de su caso.
Find sufficient evidence to find you guilty.
Y tenemos suficiente información para ponerte culpable.
However, I'm going to follow the agreement that you made with the district attorney and defer all proceedings and place you on probation for 3 years. You're ordered to pay the $300 fine and to follow all of the rules and conditions of probation. If you do everything you're supposed to on probation, this is a great opportunity because you do not have a felony conviction on your record. If you violate any condition of probation, though, you can be brought back into court, found guilty of the offense, and sent to the state jail prison for up to 2 years. Do you understand?
Yes, Judge.
I'm handing you the trial court certification that shows that this was an agreement I followed and that you've waived any right to appeal. Before you leave today, you'll need to talk to probation at that desk over there. And if you'll just help them get that information.
Yes, ma'am.
Thank you very much. You can go talk to probation now. Just wait just a minute. I'll be finished.
Okay, cuando llegues a la información. Ese es el which is inconvenient natures. No, nomás van a ir a otra predicción, pero das todo esto y ellos van a tener todos los cosas que están diciendo en un parte, cada mes para lo que
Right, this is clause number 24 DCCR 1390. Thank you very much.
Yesterday.
And so Ms. Freddie was previously in court. She's on probation for evading arrest or detention and
Judge, I'm sorry, Rob, it's actually, we reduced it to a fleeing initially.
Eluded.
And fleeing or eluding, I don't know why it keeps coming up as the evading.
okay. And so it's a misdemeanor,
That's right.
put on probation. There was a motion filed, she pled not true to the counts in that motion. We were here for, or we're actually set for hearing this afternoon. It's my understanding you guys have visited and there's an agreement reached. Is that correct?
Yes, Judge.
Yes, Judge.
So tell me what's going on.
I guess the way to call it would be a little bit of unusual agreement, but Mr. Coleman has agreed to dismiss the motion to revoke probation in exchange for essentially 2 sanctions. One would be having the court order her to do a day in jail, but with credit for a day in jail. And 2 would be to complete an anger management class through the probation department.
And it's the state's intention to dismiss the motion, and those would just be sanctions through probation, not because of me making any findings in that motion, correct?
That's correct.
right.
Essentially an amendment to her conditions of probation.
So, Ms. Freddie, what that means is that motion to revoke your probation is going to be dismissed. You're still on probation.
Yes.
It's going to be now a condition of your probation or a sanction for the allegations that you serve 1 day in jail. You will get credit for that day when you were arrested. Also, you will now be required to successfully complete an anger management class or program. I do want that started within 30 days. It's a kind of a lengthy several week program. I don't want you to put that off. I want it started within 30 days, do everything else you're supposed to on your probation. And this will hopefully just be a hiccup that goes away and you'll still be able to have that deferred probation without any type of conviction.
Yes.
Okay. And I know because it's a misdemeanor, it's also not a long probation. And so you need to get that anger management done as quickly as possible.
She's 1 year complete, Judge. And
Okay.
so, of a 2-year probation.
Perfect. So there's plenty of time for you to get that done. So get that started, get it over with, and then everything should be fine. I just signed the dismissal of the motion to revoke. Thank y'all for visiting and working that out. You're free to go.